better in a second run. So
We shall eat chips and salsa.
okay. We'll call this meeting of the Kaysville City Planning Commission to order. Of course. Do we have any declarations of conflict of interest in being trained tonight? All right, then. Our main agenda item then is going to be training on state code, various other things.
We'll start. Katie's going to do the Open Public Meetings Act, and then Will do the County Commissioner one.
Right. Is this on? We're good? Okay, so we'll just do a quick refresher on the Open and Public Meetings Act. This is required training every year, so for a lot of you, it's probably a repeat, but we'll go through it. Okay, now we're in business. Maybe. Okay, so the purpose of the act is that public bodies must conduct the public's business openly and with full transparency. And these are the elements for a public body, and as I'll read each one and then just give me the thumbs up if you think it applies to you, or the thumbs down if you think it doesn't. The first one is any administrative, advisory, executive, or legislative body that is created by the Utah Constitution, statute, rule, ordinance, or resolution. So yes or no? Okay, so we're good there. Consists of 2 or more people. Good. Expends, disperses, or is supported by tax revenue. We get that $30 every time, so yes. Is vested with the authority to make decisions regarding the public's business. So congratulations, you are a public body. So anytime you have a public meeting, the Open and Public Meetings Act will apply. Where do I point this to get it to work? Okay, there we go. A public meeting is a meeting, a convening of a public body with a quorum present, including a workshop or an executive session, whether in person or by means of electronic communications, for the purpose of discussing, receiving comments from the public about or acting upon a matter over which the public body has jurisdiction or advisory power. So again, that's going to apply to all of our agended meetings here that we've ever done. But what is not a public meeting? A chance or social gathering, and technically a convening when no formal action is taken, but we like to err on the safe side. And anytime we're getting the Planning Commission together, we want to send out a notice and have an agenda. So if 3 of you met at Bowman's and you were just there, and you wouldn't have to worry about avoiding each other, because that is a chance or social gathering. Although I would suggest not talking about items that are going to be on the agenda if you happened to be together at Bowman's and there was a quorum of you. Okay, so what does the act require? Notice to the public of each meeting at least 24 hours in advance, must include the date, time, and place of the meeting, an annual notice of all of our regularly scheduled meetings, and written minutes and recordings of all the meetings, and giving the public access to those recordings and minutes. One thing that I think is a common violation of the act that we don't think about is if you were up here whispering to each other, not talking into the mic, or texting each other about an item on the agenda, then you could be violating the Open Meetings Act. So I would suggest any discussion that you have about an item on the agenda, say it into the mic. All right, and really, that's our training on open and public meetings. We'll just summarize real quick. Public bodies must conduct the public's business openly and with transparency. A meeting is a body convening with a quorum present for the purpose of doing public business. It can be in person or electronic. A social or chance gathering is not a public meeting, and minutes and recordings are required for public meetings and subject to grandma. Any questions about open meetings?
Can I ask about?
Yeah.
I think it's called ex parte conversations. Is that something we need to worry about with applicants or anything like that?
Okay, so when you're acting as a quasi-judicial body, do they do any appeals here? Does the Planning Commission do any quasi-judicial?
Yeah, we do act as a
Yeah.
appeals body.
So anytime you're acting as an appeals body, which hasn't happened since I've been here, but basically that's when you would want to worry about ex parte communication, because your decision should be based on the evidence that's presented at the meeting. Administrative acts, it's not as big of a deal. If somebody said something to you outside of the meeting, you can consider that. Any other questions? Yeah.
Understanding is, particularly for administrative action, because you're supposed to be basing your decision on evidence and information. And if somebody tells you something that would be relevant to an issue that you're considering, when you get to the meeting, just tell the body, say, hey, I had this conversation with such and such, and this is what they said.
Good point. Yeah, all of our findings should be, the reason that you're voting the way you vote should be on the record. So that's a really good point. Any other questions? Okay. Well, there you go. You are trained for the year. Although, ask questions anytime you have them.
My question is, how come I know the line in meetings is false?
Okay. Let's see. There we go. It's been a while since I've done one of these 101s, but it's so embedded in my psyche and my consciousness that I probably still know it all by heart. But happy to go through it. And which of you have not had a 101 training yet? Has anybody not had? Oh, Jeremy, you haven't? Anybody else? Who y'all have had 101s? Okay. Well, good then. We're going to review a lot of stuff that you probably already know a lot about. But basically, we'll go through just what the... this is actually a presentation that I put together to be used by the development community. I was asked years ago by a friend of mine who was teaching a course in the real estate development program up at the U. And they, as part of the class, they would have them do like a mock project, like they were doing an application or they were going to build a project. And one of the first parts of that was getting entitled, going through the local process. And so I was asked by the class instructor, said, can you come up and go through that, how that works at local government? So I already had the 101 for planning commissioners and so on, but I put this one together, and the more I thought about it, the more I thought, this probably explains it maybe even a little better when you're looking at it from the viewpoint of the other side, you know, somebody who's going through the process, and to help learn and understand it a little bit. But it all really boils down to land use regulation, what that is and how it works, and the underpinnings of it. We won't go into a lot of the underpinnings, the constitutional issues and the court rulings and so on that have been done. There's some good presentations out there that cover that, and Craig Call, who I work with at the Utah Land Use Institute, who is an attorney and was a land use attorney, is a land use attorney, does a really good job with that, and that's something we ought to look at in the future. But did some?
A minute ago, I thought I needed to go get a new.
Oh, okay. But we'll go through this. So let's talk a little bit about, first of all, this is a real simplified version of the land use process for a community. You start off by doing a general plan. for your community. And I think some of you were involved in the latest update that we had for the Kaysville General Plan, which was a substantial update from the one that had existed previously. But that's usually the first step. And of course, you know, we'll talk a little bit about what that entails. But following that, the next step is to then implement the plan. And that's usually done by adopting ordinances and codes that will then make the things happen or allow for the things to happen in the community that you envisioned as part of the plan. But even though the city and the folks that are involved in that process, the Planning Commission, the council, even though they do the plan and they do the ordinances, by and large, they generally don't build the things that get built in the city. That usually entails somebody coming in and having to make an application for the process, so to determine if they're in compliance with what the city is looking for to have happen and may be permitted. And then, of course, once they go through that application process, then in the end, permits are issued and the projects get underway and get built within the community. And hopefully in a way that your plan has envisioned. Now, we all know that plans and conditions change quite a bit. So really the plans ought to be updated fairly frequently. But unfortunately, many times they're not. You know, it takes a long time. Communities, when I was at Salt Lake County, we had the Canyons plan, the county had the Canyons plan there. I was at Salt Lake County in about 2015, 2016, 2017. We updated the Canyons general plan. The plan was last done in 1980. That's a long time. Shouldn't go that long.
Start over, or did you?
Well, yeah, pretty much.
Probably not much to.
So when did we do our plan, Melinda? When was our plan update? 22, was it? 2022?
Yeah, the process started, I think, in 2020.
Yeah.
I wasn't here until 22.
Right.
But, and then of course that was COVID, so they kind of pivoted, adapted, did the public involvement. It took a little bit longer, I think, because of that.
Right, it did.
And then it was adopted in August of 22.
Right. That's 3.5 years. We're getting close to the point where it probably should be updated again.
Is that a normal, like every 3 years?
No, 5. 5 is generally kind of the rule of thumb. But depending on conditions, sometimes things change so much that you probably ought to do it sooner. So it really kind of depends. And, you know, we're doing the downtown small area plan, which is good because I think that's an area that needed more focus. So in a way, we're kind of doing some updates of it as we go along already, which is good. All right. So, here we go. So this is the planning process. It's part of local government. How does it work in local government? I have an entire presentation that talks about what it really is that planning is politics. And, you know, I think a lot of planners, when they first come out of school and people, when they get involved, they think, well, this is all objective stuff, you know. There's the science and the experience out there, and there are the right way and the wrong way and the best way and the not best way to do things. And so it's all pretty straightforward. We just need to make sure we have those things. Well, that's really not what it is. It's really a political process. It's part of local government, and local government is politics. And what is politics? It's kind of deciding who gets what. And so I have a whole presentation based on that. In fact, for a while I was teaching a course up at the U called The Politics of Planning. And the planning students that would take it, partway into it, as we got more and more into what was happening and how it worked, they would say, and almost uniformly, every student would say, oh man, every planner should know this. And I was like, yes, every planner should know this. But for whatever reason, after a few years, the powers that be at the U said, I don't think we need to teach that class anymore. So it was cut. And I find myself thinking, okay, but When I was planning director at Salt Lake City, we would hire students that came out of the U, and invariably they had to be educated on how things really worked, how you got things done, and why decisions were made the way they were made. So, but that's another process, another thing we can talk about another time. So let's talk about the local planning process. The local planning process really has two main focuses and two main processes, the administrative process and the legislative process. There is a third one that Katie mentioned, which is the quasi-judiciary, and that's an appeals process. The appeals process is part of this, and you'll see where it fits in to all of this. But it's really kind of a subset of the administrative process that we're going to talk about here a little bit, and what the difference is between the two. So let's get into that and start talking about it. All right. Whoops. So the administrative process, there are certain actions that are categorized as legislative, and they are these: the adoption of the amendment of the general plan, the adoption or the amendment of the land use ordinances, which includes zoning, subdivision code, other land use related codes and ordinances, design standards, and so on, which of course that includes the zoning or rezoning of property. That's all legislative action, and annexations. Annexations are a legislative process as well. The last couple of years I've been chairing a working group through the Land Use Task Force, which is kind of run by the league, to look at annexations. The main purpose of it was the state code on annexations was a total mess. It had gotten that way from the 90s on, when there were these huge annexation wars that were going on in Salt Lake County, and eventually resulted in what were called the townships, and then the townships went away, and then they came back again, and then they've kind of morphed since then, but you had a lot of issues and a lot of battles going on. And every year there were bills on annexations, and there were conflicting provisions, and it was all over the place. We just finally got to the point of saying, it's time, we need to clean it up. Especially things have settled down in Salt Lake County quite a bit relating to annexations. So we felt like we could do that. But what we also realized and learned is, as communities grow, if they're going to get bigger, and they generally will because growth continues to happen, they'll generally annex land if there's land available around them and if it's developable land. And what's the process for that? And what happens to that land? What happens to that land before it gets annexed into the community? Sometimes it can affect what may happen with the community. And so there's a lot more churn going on now at the state level with annexations outside of Salt Lake County, because Salt Lake County is pretty close to being done. As of 2027, almost all of the unincorporated county is mandated by state code to be within a city. But other counties, the process is still going on, and so it all relates to growth and the management of growth, but it's a legislative process. And a legislative process, this is what it is, what these legislative actions are. Yeah, by all means, please ask questions and let's talk. Yeah. Yes, yes. It's the only one we have in Davis County. The interesting thing about Mutton Hollow is, for a period of time when the ability to create townships existed in the state code, mainly it happened in Salt Lake County, but a few other places took advantage of it and quickly formed a township, and Mutton Hollow was one of those. And it's kind of interesting because if you know anything about the Mutton Hollow Township at all, they elect their members. They're an elected body. It's pretty much all up east of Fairfield.
It's still Kaysville, we call it unincorporated Kaysville, but they're just not part of our infrastructure, their building's different. Their business licensing goes through Davis County.
Right.
It doesn't come through us.
They're actually part of the county. Yeah. They're actually part of the county, and they're governed by the county. The county commissioners are like their council. But their planning commission is elected by the residents of Mutton Hollow. And they were also pretty independent, and they do stuff on their own in regard. There was a whole issue. They created a water system years ago when I was working at Davis County. And they got a grant directly from the state to put their own water system in. State level permits for water systems did not mirror or reflect a lot of what cities and communities were requiring for water systems at that point. And when that water system was put in, it didn't take long for Kaysville City, who was on a contract with the county to provide services to them, didn't take long for the fire department here to figure out that if they ever had to fight a fire in Mutton Hollow and they hooked their fire equipment hoses up to their water system, they were probably going to collapse their water lines. And so Kaysville withdrew from providing fire protection. They didn't want the liability, the potential liability of doing that. I don't know if Layton City's providing them the fire protection. Somebody's got to be doing it, and I don't think it's Kaysville any longer. Hasn't been for some time, but it's interesting. Just kind of interesting, some of the issues that go along with that. So,
My father-in-law's one of the guys.
one of the elected planning commissioners. Yeah.
Yeah, the Mutton Hollow is actually in our planned annexation area. However, the city doesn't want to annex because the water system is deficient. And so, like, there's been some very high-level brief conversations in the last few years with the county, who doesn't want to have the responsibility anymore, would prefer that the city annexes it, but we don't want to take on a failing water system or a substandard water system. And so the conversation has essentially kind of concluded at, until that water system is brought up to certain standards, there's really not a negotiation of annexation, because, again, we wouldn't want to put that burden on our taxpayers or our water users. And I think, is it about 250 residents, I think?
I don't remember. I don't know how many there are in there.
Yeah, so.
And another issue, of course, is that they are served by Rocky Mountain Power, or by Enron,
Yep.
or whatever they're called now, Power. So if it were to be annexed, the city would have to acquire the power system there. It is possible that they can run it separately, but that always leads to issues. Cities where they do that, it's not a smooth thing. So there's a lot of issues around that. So, but we digress. That's okay. That's all right. All right, let's go on. Legislative actions are these kinds of action. These relate to the adoption of policy and rules to implement the policies. So when you do a general plan, that's what you're saying is you want the community to be like, right? This is what our aspiration for the community is. That's a policy. It's not a rule yet. But then, based on that statement of aspiration, then you craft and you put in place rules. And that process of crafting those rules and putting those into place is a legislative action, because you're implementing or getting into implementable form your policies to make them happen.
Although we don't do legislation with the planning commission, like we make recommendations and then as the city council.
We'll talk about that. Yep. But yeah, you're right. These decisions are more political than they are legal. In other words, if people challenge a decision that the city makes about their general plan or about the code that they've adopted and the rules that they have in place, more likely what will happen if it goes to court, the courts will say, hey, that's at the discretion of the city. You know, yeah, it may be a stupid rule, but they have the right to be stupid. So the courts aren't going to overturn it. As long as it's not illegal or clearly unconstitutional. And when I say that, people say, well, what do you mean? And I say, well, okay, let's suppose that you put in place in your zoning code a rule that said, okay, in this zone, we do not allow people of minorities to live. that is clearly unconstitutional and would not be allowed. And in that case, the courts would strike it down as being unconstitutional. So it has to fall within that framework. But if somebody says, hey, look, that just makes no sense, you know, to allow for a landfill to be located right there next to this residential area. And the courts would probably say, well, it may be a stupid decision, but they have the right to be stupid if they want to. They're not going to overturn it. So that's what I mean when I say it's more of a political than a legal decision. The preferences, and that goes to what this is, the preferences of the legislative body is given broad deference by the courts. They're usually challengeable in the courts only if there is no public benefit at all, it's clearly illegal, as we had just talked about, it's unconstitutional, and let's see. There we go. Now, these types of decisions are what we call referable. Under the Utah Constitution, the laws and the rules that are adopted by legislative bodies can be challenged by the public. And it's done through a process called referendum. And we'll talk about that a little bit more, but what that means is the citizens have the right to go out and say, we don't like that. We don't like that you said that this is going to be, you know, this kind of a zone or whatever, and maybe something else altogether. This has happened several times recently at the state level, and you've probably seen a little bit about this, where the legislature has adopted something and the citizens have gone, what the process is, you go out and collect signatures. If you collect enough signatures in enough places, in the designated places, then it will be put on the ballot, and the citizens will have an opportunity to vote on it. We have had land use decisions in the state of Utah, and even close to us, put on the ballot and voted on. Layton had one several years ago, where they had quite a plan for the area out west, particularly the area that had been an old LDS church farm. And the residents around it didn't like the plan that Layton had put together. So they went out, they collected signatures, they collected enough, it got on the ballot. At the next election, it was voted on, and the citizens voted it down. So it can happen. So it's because they are legislative actions, they're subject to that. Legislative actions follow this process. They go to the Planning Commission first, and state code requires that land use actions, general plan, adoption of the ordinances, land use ordinances, zonings of property, they're required by state code to have a recommendation from the Planning Commission. So they have to go to the Planning Commission first. What the Planning Commission does is only a recommendation. It then goes to the elected officials, and the elected officials, the council, makes the final decision on this. They may agree with the Planning Commission, they may not. It's their prerogative. They have that. But the idea is that the Planning Commission deals with this stuff on a regular basis, hopefully develops some expertise in there, collects the information and the data that they need, and will make solid recommendations to the council. But it is up to the council then if they want to accept that or not. They don't have to. There's nothing there that would require them to do that. All right, let's see, where are we at? Okay, now we'll go on and talk about administrative actions. This is a whole separate category of land use actions that are undertaken. The kinds of things that are administrative actions, like the issuance of building permits.
I want to know where you got this picture from, because that is not what our front desk looks like.
Well, Mindy,
Which one am I? I don't know.
I put this together how many years ago?
Okay, just making sure this wasn't right.
Wasn't even in Kaysville. Site plan reviews, conditional use permits. That's probably the most common administrative action that's undertaken now by the Planning Commission. And I'll tell you how that works, what that process for that is. But subdivision reviews are an administrative action. And really any kind of application under the land use codes and ordinances, they're handled through an administrative process. all right? Now, what's the difference between an administrative process and a legislative? Well, before I said, well, we'll talk about that, but this is where items are being considered under the rules that you've already adopted. You adopted your zoning code. This is what our zoning code said. Somebody's applying now to do something under your code that has been adopted through the legislative process. I don't know where to point this to make sure it works. There we go. This is vice versa from the other one. These decisions are more legal and technical rather than political. What it really means is that, does the application comply with the rules? It's not whether it's a good idea or not, which is what we were doing before under the legislative, but in this case is, are they following the rules?
And if they are, we generally recommend.
If they are, you're usually approving them. You're not recommending, and we'll talk about that here. If these things go to court, there's a strict standard of review. There must be substantial evidence for the action that you're taking. Substantial evidence means essentially that you've got information that's been presented to you that gives you a basis for hanging your hat on it and saying, yes, this meets the requirements of our code or ordinance, or no, it doesn't meet the requirements of our code or ordinance. That you have to have evidence in place in order to do that. That's why a lot of times when we have these actions, when we have like a conditional use permit or something here at the Planning Commission, and we say, well, based on these findings in the staff report, because in the staff report they've listed, it meets this, it meets this, it meets this. Generally, the staff will, if you're going to get a staff report and they're recommending approval, it's because they meet all of the requirements. Not often are you going to get an administrative action that's going to come that doesn't meet the requirements. But it may happen that you get some information during the meeting that then makes you say, oh, wait, wow, yeah, that doesn't meet our requirements. The most common thing that I get asked about is, well, okay, so, and I've seen this several times in my career, all right? One of the big issues. So whenever you have an application, particularly for development, like a new subdivision or an apartment complex or something, citizens usually come to the meeting, and they're usually opposed to it. And that's because usually only the people that are opposed to it come to the meeting. People that are in favor of it or don't care, they usually don't show up at the meeting. But the people that do come to the meeting and object, there are usually three things. The three most common things that they raise as objections to it. It's going to lower my property values, it's going to increase traffic, and it's going to kill kids. Those are the three most common things that you're going to hear. And almost invariably, you hear them on most of these. Well, increasing traffic, any kind of development is likely to increase traffic to some extent. But is it going to be enough to make the street non-functional or to cause big problems? And so sometimes in order to make that determination, there's a requirement that the applicant has to do a traffic report or a traffic study. And they'll do that. Now, depending on how big the development is and how big the opposition is, I have seen, this has happened several times in my career, as I said, that an organized citizens group will put up the money and they'll get a traffic report. They'll hire an engineer and they'll get their own traffic report done. And guess what? That traffic report says the opposite of what the developer's traffic report says. They're both licensed and credible engineers. So now what do? And people ask me that all the time whenever I do these kinds of trainings. Planning commissioners, they say, yeah, what do I do? How do I handle that? This issue of substantial evidence, what it really says is if you have something like that, you just need something to hang your hat on to say, well, we got a report from a qualified and certified engineer that said that it did meet the requirements. Or we got that and it said it didn't meet the requirements. You can really go either way based on your own personal judgment because you've got something to hang your hat on. It's not just your opinion and it's not just somebody else's opinion. That's a big mistake that's often a lot of times made in these kinds of hearings is, like, the developer has the traffic study, and usually it's reviewed by the city, and the city will say, you know, yeah, we think this is good or not good. But usually, if it's to you, they've usually said, we agree with it, it's good. But then the residents come in and say, it's going to increase traffic and it's going to kill kids. It's going to be really bad. What do you have as evidence to show for that? And usually they don't have any evidence. It's their opinion. And that's not substantial evidence to hang your hat on. If you make a decision based on that, and the developer decides to take it all the way to court, you're likely to lose on that basis. If I can tell you a great story. The stories are more fun sometimes you're going through all this stuff, right? So maybe you all heard about the term public clamor, right? You're not to make administrative decisions based on public clamor. Public clamor is just that, people coming in and saying, we don't like it, we don't want it, and then the body makes a decision on that basis. That term came out of a court case from Clearfield, and I was the planner. It's my claim to fame. What it was an alcohol and drug rehabilitation home. They were buying a house in the neighborhood. It was actually on a major street, so it's kind of hard to say it was in the neighborhood, but it was a house and there was a neighborhood around it. And the residents absolutely did not like that. That's not an unusual reaction. A lot of information was presented, but the room was packed with the citizens that were there, the residents in the neighborhood that did not want this facility. And one of the claims they were making was, it's going to increase crime in our neighborhood because these folks are going to go out and they're going to break into our houses and stuff because they're drug addicts. They were, and they're still doing stuff like that. The interesting thing was that was brought up numerous times. Because there were so many people and it was such a contentious meeting, there was a delegation of police officers in the meeting, including the chief. The chief was there at that meeting. And the Planning Commission chair, after hearing this a few times, said, Chief, is that true? Do these kinds of facilities result in an increase in crime in the neighborhood? The chief, who would be considered an expert in, and if you go to an evidentiary hearing and you say, well, yeah, this man is credible as an expert, he got up and he said, no, we don't usually see that. We don't see with these kinds of facilities that crime goes up in the neighborhoods around it. Well, the meeting went on, a lot of other stuff happened. The Planning Commission made the recommendation, or made the decision, and then it was appealed to, and the City Council did the same thing. And one of the reasons that they cited for denying the permit was that it will increase crime in the neighborhood. That was one of the things that the court then hung their hat on and said that was public clamor, it was not evidence. And you can't make decisions based on public clamor. So that's what that is all about, why you need to have that information or that evidence in order to do that. Oops.
It's probably hard to not distinguish between public clamor and evidence, but it's hard not to get caught up maybe in comments and emotions.
Oh yeah, it's very hard. I mean, you've been here and you've seen some of the meetings, and I've been in meetings that have been 10 times worse than anything I've seen here. And when you're sitting here and you have a room full of angry people in front of you that are like yelling and saying, don't allow this, it really is hard for that body to say, okay, yeah, well, I think we're going to go against these people and approve it anyway. It really is a hard thing. Yeah, it's a really hard thing to do. And it becomes even harder for the elected officials because they have to get votes from those people. And so that's why we don't recommend that administrative actions are done by the elected body.
Well, can I ask a question?
Yes.
So I'm just thinking of the times that, like, I've seen it here, and a lot of times it's a rezone, but that's legislative, so you could consider public clamor if you want to.
Yes,
But
absolutely.
like maybe the Boondocks one, that was administrative, and that we could.
Right. Yep. So that bullet point there is no public clamor. There must be evidence. We've just kind of beat that one to death.
Well, if I can just add.
Yeah, please go ahead.
So we, So state code defines who the land use authority is for certain things. And in Kaysville, the land use authority for any of the administrative actions is either staff or the planning commission. And going back to the whole, there has to be evidence, you make a decision based on evidence. One of the things that we built into our bylaws is that if somebody wants to submit something to be considered as part of the record, we have a deadline of 1:00 p.m. 2 days before the meeting. And that is because, you know, if it is a conditional use permit and somebody does bring in an alternate traffic report and they hand it to you during the meeting, how are you supposed to have adequate time to review and consider that to then make a good decision? But if we accept it, it becomes part of the record. And so that is the rationale as to why we put that deadline in. Now, less concerning when it comes to the legislative recommendations, right? But because, you know, if we did have an appeal, which we have had one appeal while I've been here, you know, but anything that would have been handed to the planning commission during that meeting, if we accept it, it becomes part of the record. But then again, is there adequate time to review and understand and comprehend that to make a good decision? So that's been put in as a protection to make sure that you do have adequate time. Now, with the bylaws, right, we can always suspend a rule, you can have a vote and choose to accept that information past that deadline. But then I would recommend, if you were going to do that, that maybe you table or continue an item to the next meeting so that it could be reviewed and adequately considered.
So where we did last meeting, the resident passed out, multi-page pamphlets to each of us. Because she handed that to us, does that count as accepting it?
It goes into the record.
So we would have to say.
She didn't submit all of it.
Yeah, some of it had been submitted and some of it hadn't. And so
But that one was a little different because that was a legislative action. That's based on opinion. You know, you can consider all kinds of stuff for a legislative.
Rule that has to be submitted in time to be able to review it?
Well, that rule, I believe in the bylaws, I'd have to double check, but I believe that it doesn't apply to like one type of action or another, whether it's a recommendation or an actual land use decision. But something to be mindful of, and again, less concerning when it is for a recommendation. And what we do, which I mentioned in the last meeting, right, but we do want to make sure that we carry that information forward when it goes to city council. So the fact that it was handed in and received, like we've scanned that, it'll be included in the packet when it does go to city council. But in the case of like a conditional use permit or something like that, that you are the final decision maker, I think it becomes a little bit more critical that deadline be adhered to, right? And it could be something as simple of like, I have this photo. Okay, that's gonna take, what, a minute? You know, that may be something that could be doable up at the dais. So, you know, we do have that discretion, but you do also want to be very careful because that could be something that could negatively impact an appeal, and those can be costly and time consuming.
How do we react then if someone, like she did, just throws it up to us?
Well, yeah, I think for one, like one of the things
Gather it up and go back to her? Like,
we can, yeah. I mean, had it been something, right. Had it been something like a conditional use permit, I probably would have interjected and mentioned that. We're going to be bringing a bylaw amendment to you at one of the next meetings, and then I think we should kind of review those. Obviously, being familiar enough with them helps that. But yeah, it can be awkward. And we even had a discussion with our staff, with me and Ann and Mindy, the other day about maybe even including on the back side of our public notices that we mail out some type of information, or at least like, so that people can be prepared for that, because we did have that 2 weeks ago, and we had people calling that day, residents saying, well, I want to provide a presentation during the meeting. And it's like, no, you get 3 minutes of public comments. We can't take a presentation from everyone. You know, so I think there's flexibility when we need it, when it's appropriate. I think that we can fall back on that if it is going to be something that wouldn't be enough time to consider. Just kind of.
Could the chair ask for a vote to accept it then? Is that?
Yeah, you can always do that and kind of suspend the rules with a vote of the body, or if it was in there, it could be the discretion of the chair. But that is something, you know, that it could be problematic, right? Yeah, you know, that traffic study is 140 pages, or the information from the resident. You had received a bit of that information through the email portal, but not all of it. And you know, and I didn't really know if we were going to get to a recommendation by the end of that night. So again, you know, I wasn't that concerned about it, but you know, staff, legal counsel, having the chair and the planning commission members kind of aware of that, which we're committing to doing a better job going forward of having all of that information, and again, trying to have that even on the backside so residents can understand that if they are going to submit something, that there is a deadline. I know it's kind of hard with those public comments too, that they come in. I mean, we still have sometimes comments coming in while we're in our meeting. We still, again, always do forward all of those to the council when it gets to that point, but especially because most communities, actually this is something that I feel, I love that Kaysville does it this way, but most communities actually have 2 public hearings on legislative items. They do one at Planning Commission, which state law requires you do it at Planning Commission. Most communities will do a second one at your city council level. Kaysville, I don't know how many years ago, but Kaysville decided to just do with Planning Commission. And so because of that, I have really endeavored to make sure that, because there's not a second opportunity for a public hearing at council, that we include everything in that packet for the council. They need to see those emails. We get either the minutes or a link to the meeting included in the staff report for council so that they can see all of that, because it's not a repeat at the council meeting like it is with the Planning Commission.
Yeah. All right, so these administrative actions, if someone disagrees with the administrative action that was taken, you recall that for the legislative items, we said they're referable. Citizens can collect signatures and get them put to a vote. That's not what happens with administrative actions. Administrative actions are subject to an appeal process, almost kind of like, I mean, they could eventually wind up in court. But the first step before it gets there is the local government has to have what's called an appeal body, and the appeal body hears appeals of administrative actions. And so if there's a neighbor or someone who's affected by it who wants to appeal it, or let's say that the approving body turned it down, the applicant could appeal it. And then it goes to this appeal body, and we'll talk about the appeal body here in just a sec. But it's not a referendum process for administrative actions. It's a more formal process that happens for that. All right. The administrative actions are to be cited by what's called a land use authority in the state code. A land use authority can be a variety of things. It can be a staff person. And we have that, like for example, before a building permit can be issued, there needs to be a review done to see if they meet all of the setback requirements, the lot size, the frontage, all of that for the lots. That's all usually handled at the staff level. Well, and that staff person can then say, yes, it meets it, or no, it doesn't that staff person is a land use authority by doing that zoning review in order for the building permit to be issued. It can be the planning commission. And oftentimes, in most jurisdictions, planning commissions are the body that decide on conditional use permits, decide on site plans. It was for subdivision plats as well, but that process has been changed in state code a bit now. That's all part of it. That's the land use authority can also be the council. We as planning professionals don't recommend that. And the reason we don't is because administrative actions have to be based on evidence and not public clamor. Council members tend to be more political. They are concerned about votes for future elections. So often you see the decisions made really kind of on that basis, rather than for the objective evidence. They're kind of made more on the, well, am I going to get in trouble with a lot of people voting or objecting to this? And so that's why we recommend that not happen. We see councils being the land use authority in a lot of smaller communities. And one of the main reasons they do that is they just say they have a hard time finding people to serve. And so they do it themselves. But in other jurisdictions, most of those around here along the Wasatch Front, the land use authority is either the staff or the planning commission. And then you also have to have an appeal authority if it ever gets to that point. Used to be that appeals were handled by a body called the Board of Adjustment. That language was taken out of state code a number of years ago, and many jurisdictions no longer have boards of adjustment. They now have a hearing officer. And usually that person will have at least a little bit of legal training, because you're kind of almost into a court-like process in order to hear an appeal based on evidence, based on rules, and so on. And so it's a little bit more formalized in order to do that and go through that process. Okay. So when you're, the Planning Commission, considering a conditional use application, you're not doing it as a planning commission. You're the land use authority at that point. That's really the designation in state code that you're under, and you're doing that as an administrative action and have those rules to follow under administrative actions. Okay, let's go on. Let's kind of go through the idea now of someone who wants to do something. They want to build something in your community, so they come in to make an application. And here's what they need to do. Here's what they need to go through. Really, the first thing they need to do is they need to check the local codes and ordinances and to see the property that they're looking at or that they may be interested in, is it allowed? What's it zoned for? What can be done on that property? Now, there's an interesting thing about codes and ordinances and what they say and now what exists in state law, and it's all based on what happened in a court case clear back in 1995, so 30 some odd years ago. And I'll give you an example. A lot of codes and ordinances, especially early in my career, I would see this a lot. Codes and ordinances would say things like for a conditional use. They'd say, it must be compatible with the neighborhood character. What the heck is that? Right? Or there are other provisions like that that are really kind of vague and not very specific. What it really left is for a lot of discretion on the part of the approving body to say, well, yeah, we think it is, or no, we don't think it is, and based a lot of times on the public comment that they would get or whatever. What the court in this particular case in Utah County said, because zoning ordinances are in derogation of property owner's common law right to unrestricted use of his or her property. In other words, you're taking away the right for them to use their property however they want. Provisions restricting that use should be strictly construed. In other words, look at it very carefully what it says. And the provisions permitting property uses should be liberally construed in favor of the property owner. What that means is, if you have a provision in your code like that must be compatible with the neighborhood character. And a person, a reasonable, average person can say, well, look, the city body is saying, well, they think it is or doesn't comply or does comply because of this and this and this. But the applicant or somebody else is saying, well, they think it doesn't comply, or they say the opposite because of this and this and this. And if an average person can look at that and say, they both have a point. You know, I can see that, but I can also see that. If that's the case, what this court case said is, then you need to decide it in favor of the property owner or the applicant in that case. And that has since been put into state code. Back a few years ago, it says the land use authority shall apply the plain language of land use regulations, and if the regulation does not plainly restrict the land use application, the land use authority shall interpret and apply the land use regulation to favor the land use application. So what we as professional planners and attorneys are saying now is make your code specific. Make it clear what you're saying and intending, because if it's not clear, if it's somewhat doubtful, somewhat dubious, then you may not get the outcome that you think you're going to get. So that's just something to be aware of. So as an applicant, you're looking at that code and that ordinance and saying to yourself, does this allow me to do what I want to do? And even if it's vague, you still may be able to do what you want to do based on things like this kind of ruling. Okay, so that's your first step. Check the zoning, check the local regulations. A lot of times also you may be looking at the general plan. Take a look at the general plan for the community and see what it says. And see if what you're proposing is consistent with that plan. And let me talk about that right now. So, if it's in the plan, they have to follow their plan, right? Yeah, you guys are too smart here. You've been around long enough. No, they don't have to follow their plan. The state of Utah is one of a number of states where land use plans, general plans, are advisory. They're advisory. They're not regulatory or mandatory. So what that means is you can look at it and decide whether you want to follow the plan or not. And that would come into play when you're thinking about what codes and ordinances to adopt, and probably more frequently in whether to rezone property or zone property. Because your code may say, well, you know, you're supposed to allow higher density housing over here. But the Planning Commission and or the council may say, yeah, I don't think we want to do that there right now, and they can. They can do that because plans are only advisory. There are states where plans are mandatory. They have to be followed. And in those cases, you know, it gets pretty hard to try to do something different. We have had, over the last few years, there's been some action to try and make Utah a mandatory plan state. It hasn't succeeded at this point. And part of it is because the development community is saying, well, look, then we get away from these big zoning fights, these big rezoning fights. Because once you've adopted your plan, then that's it. Then you have to follow your plan. And those of us who've been in this field for a long time say, all you're going to do is you're going to shift the fight from the rezone hearing to the general plan hearing adoption. That's where the big fights will be. You're not going to get away from the big fights. And so, more frequently, yeah.
Well, what happens, and again, Kaysville does not do this, but most communities then have an application for a general plan amendment. So if you wanted to rezone a parcel to general commercial, but it showed as residential, then you submit an application essentially to amend that plan, and it usually has to do with the future land use map, and change that future land use map from residential to commercial. Then you can proceed with the rezone application. Now, if that general plan amendment application doesn't pass, you know your rezone isn't going to pass. Some communities would allow you to do both a general plan amendment and a rezone application concurrently. Some people may want to choose to do a general plan amendment to see where that lands before they spend money on a rezone. But in Kaysville, I actually, when we adopted the 2022 plan, I had some internal discussions, actually reached out to Wilf and kind of got some thoughts about, do we want to do general plan amendments? And we essentially kind of fell back on, well, they're advisory. We don't have to. It lengthens and complicates the land use process. So let's not do general plan amendments.
Yeah.
And so that, I think I have not regretted that decision, but,
Yeah. It's really up to the community how they want to do it. A community can decide, and they can even put it into their code or ordinance to say that land use actions have to comply with the general plan. Salt Lake City does that. So if somebody came in with an application in Salt Lake City that did not match with the general plan, they were required to do a general plan amendment and a land use code amendment. And the Planning Commission, the council would not even consider it if it wasn't in conformity with the general plan. And if it wasn't, they could apply to amend the general plan. And they pretty much held to that. They said that's the way it's going to be here. Not all communities do that. In fact, many don't. They take it much more on a case-by-case basis. And they're allowed to under the law. It is a provision in state kind of practice that's the way it goes here. So just something to be aware of, all right? So as a developer, you're looking at all of that. What that may mean is that you maybe need to look at amending the plan if it doesn't allow for you to do what you want to do. You may have to rezone your property, or you may have to amend the code to allow for something to occur the way you want to develop. And all of those things are very possible. You just go through the legislative process in order to do that, the process that we kind of outlined at the beginning. And in order to do that, it kind of is this process again that we talked about. The Planning Commission has to hear those first. It's required in state code. The Planning Commission has to hold a public hearing. They're required by state code in order to hold a public hearing on those legislative actions. And then it goes to the council, and the council ultimately decides. Now, as Melinda said, I wasn't really, I hadn't followed it that well, but a lot of communities do hold another public hearing with their council, but it's not required. State code does not require another public hearing by the council. So a lot decide on their own that they want to do that, but it's not required. Okay, so just to be aware of. And again, those legislative actions are subject to referendum. That is, people who don't like it can go out and try to collect the signatures, get it put on the ballot, and have it voted on. I put this together a few years ago, but there was a period of time there where we were seeing a lot of referenda going forward on local land use issues. It's kind of tailed off lately. I don't see a whole lot of those anymore right now, but there were for a while. There were a lot. And I kind of put this up there as just kind of a demonstration that it does happen, okay? All right, so now you proceed forward with your application. You submit your application, you've got the code in place, you've got the zoning in place that you want to do. You submit your application. When you submit that application and you pay the fee that goes with that application, you now have what's called a vested right. Utah is what's considered to be a liberal vesting right state. What that means, what the idea means is, on the day that you submit a complete application, and that means included paying the fee, if you submitted that and all the information that you're required to submit, you now have the ability to proceed under the code that was in place on the day you submitted that complete application. Now, jurisdictions will sometimes change their code while an application is in process. Then the question for some of these becomes, well, do they have to follow the new code or the old code? In the state of Utah, you follow the old code, even if the code gets changed in the middle of the process. And just to give you the sense of this, I've seen this happen on several occasions. An application comes in, and people they look at that application and where it's going to be located, and they say, heck, we don't want that there. We didn't want that. And so they say, let's hurry and change our code. And then they try to hurry and amend their code and change it so that before they get through the process, now the code's changed and now they have to follow the new code. I have to say that happened in our own community. Y'all remember the car washes? And we were all like, wait a minute. Why are we getting so many car washes? We don't want that many car washes. Well, our code allows it. Well, then maybe we need to change our code. We did, you remember? And do you remember that we had one pending application? We couldn't do anything about that one because of this vested right rule. But shortly after that code was adopted, we had another applicant that came forward and said, hey, make an exception for me. And we were like, no, the code's been adopted now. So yeah, it's something to be very much aware of, that there is this vested right rule. Some states have a very, I don't know if you'd call it conservative or whatever, but I'm aware of an instance where in a particular state, an applicant had actually started building their building, and they had built it up to 9 stories. And while they were in that process, the community changed the code. They actually had to go back and remove a couple of stories from that building that were already built because the code had changed before they finished it. Yeah, that seems pretty extreme, but it was allowed under the law. The powers that be here in the state of Utah said, no, we're not going to do that. And it's kind of flipped pretty far the other way, but it's a rule. As long as we understand what it is, then we know how to deal with it. And that's what the rule is here in the state of Utah. All right. Again, the application is then reviewed by, usually the first step is the staff takes a look at it. They make a determination as to whether they meet all of the rules, the code of the ordinance. And that's oftentimes an iterative process, you know. An applicant will say, okay, here's my application. And the staff will look at it and say, oh, yeah, but you got to change this, and it doesn't meet this requirement, and it doesn't meet that. And the applicant will go back and make some changes and then come back. And then, you know, it's kind of a back and forth thing for a little bit until it kind of all gets hammered out. In some cases, like I mentioned, with the building code or a building application reviews for zoning, the staff just handles that, and then they do the final approval. But oftentimes that land use authority, it comes like to the planning commission, like for a conditional use or something. Because of that process it's been through with the staff, generally, when it comes to the planning commission, as you're acting as that land use authority, generally the staff will have reviewed it and it meets the rules or requirements. I have seen instances where an applicant has been told, you don't meet the requirement, and the applicant says, well, I still want to get a decision on this. I want to see if they'll approve it anyway. And, you know, as staff, we say, they're not gonna, because you don't meet the requirements. And they say, well, I still want to. So you go to the meeting and let them get turned down. They have that right. They have, yeah. And it's also happened, I've also seen in meetings where you have an application that the Planning Commission has said everything's okay on this, and then at the hearing, somebody gets up and actually provides some information that nobody seemed to know about. And all of a sudden, the Planning Commission goes, wait a minute, if that's the case, I'll give you the example. So I was the planner for Centerville City, and we had an applicant that wanted to put a service station on a corner property. And everything seemed to be fine. You know, they were made to meet all of the requirements. Everything looked fine. They came to the meeting. Staff we had recommended approval. Said, you know, it meets all the requirements. There was an old farmer sitting in the meeting, and he didn't say much for a little bit, but then he finally said, it ain't gonna work. And the Planning Commission was like, what do you mean it isn't gonna work? And he said, He says, I farmed that property for 50 years. He says, it's not going to work. And they said, well, why not? And he said, because there's a buried well capped right there. As soon as you dig down into there, you're going to uncap that well and you're going to have water running all over the place. Nobody knew that. Nobody knew that. And sure enough, when the applicant, the new owner of the property, went back to check it, sure enough, there it was. So they had to redesign their project. Well, nobody, if they had approved it, could have been quite a little fiasco, a disaster there, but somebody brought some information in that nobody knew. And so it can happen. It's just something to be aware of and to know about, all right? So, that's what I wanted to talk about under this issue of public hearings. What's the value of public hearings? And really, for legislative items, there's no question about the value of public hearings because you're gathering opinions. You want to hear people's opinions and people's feelings. I will put this one caveat in, like for particularly like rezones, okay? The people that show up are the people that are against it. You're not hearing from anybody else. So you may not be hearing the whole sentiment in the community and everything else out there. So just be aware of that. I've seen several studies that have shown that the people that come to public hearings, for land use public hearings like that, are generally homeowners, older, not racially diverse, okay? And you pretty much get a pretty standard view from that group of people. It may not be representative of the whole community, and oftentimes isn't. So it's just something to be aware of as you consider for a public hearing. We really discourage public hearings for administrative actions because generally, what do people come to those hearings for? I don't like it. I don't want it. I don't want that in my neighborhood. It's going to lower my property value. It's going to increase traffic. It's going to kill kids. Oh, okay, do you have any evidence on that basis? No, I just know it's going to happen. Well, but having said that, there are two maybe good reasons for still having public hearings at an administrative action. One is the community at least feels like they got a chance to say something about it, okay? Because so often they'll come in and they'll say, we didn't even get a chance. We didn't get to say anything about it. The problem is, if you do have a public hearing on administrative action, then they just bring up, like they usually do, mostly opinion, and then when you're ready to take action, you say, well, they meet the requirements of the code, we really have to approve it. And then the public members say, they didn't listen to us, they don't pay any attention to us, they ignored us. Well, I had no choice.
This was the gas station.
Yeah.
I think it is frustrating for the community if they don't understand the difference. So what's the point of all of us showing up? And, you know, we heard from little kids, we heard it from everybody. And
Yep.
they anticipate that it will make a difference and it really kind of doesn't.
It really can't.
It shouldn't.
Yeah.
But they're not aware of that. I think it's frustrating for them.
Yep, it is. And then the other good reason may be that, yeah, sometimes you actually do get some information that's actionable. You know, something that nope.
Being close to a school and different things like that.
Yeah.
There's some good things come out of that.
Yep.
Meeting,
Yep.
some good discussion.
So,
Even if it wasn't valid, some good points brought up that you're like, oh, we should check. We should check how close that is.
yeah,
Things like that.
yeah.
I remember learning.
So, you know, you've gone through with your application. There may be an appeal. If you got turned down, you may want to appeal it. If a neighbor didn't like the action that was taken, the neighbor may appeal it. You go through the appeal process. The appeals process is what, as Katie described it, it's a quasi-judicial process, which means it's kind of like being in the courts. You have to present evidence. You have to present information, and you have to follow certain rules in the presentation. Generally, most local ordinances are written to say that the appeal is only to be based on the evidence or the information that was presented to the body that made the decision. It's not a place for new information or new evidence to be presented. It's generally just that. But sometimes, in some situations, it does allow for new evidence to be presented, but usually not. It's usually only to be decided on the information and evidence that was presented in the hearing or in the meeting at which the decision was made, and that's what the appeal is based on. And then usually the person who's bringing the appeal, they have to demonstrate where the deciding body made a mistake. They did something wrong, and therefore it should not have been approved or should have been approved, whichever way it goes. So, and then of course the final move on the application after going through the appeal process is it may go to the courts. And the courts have the rules, as I mentioned, based on that. All right. Other things to be aware of that applicants need to face is communities usually have adopted design standards for the improvements that are going to be public. So the street design, all of the specifications for streets, the water lines, the sewer lines, all of the things that are going to be installed for that will then need to be maintained by the public, they have to meet certain design standards. And those have to be adopted by the community through the legislative process. They go through the same kind of a process, and an applicant has to follow those design standards, will generally be made to follow and consider those design standards. All right, there we go. An applicant may also face what are called exactions and impact fees. That is, your development is going to have an impact on the community. You are going to increase traffic, probably, with your development. You may require more water to have to be brought into the community or service, or sewage capacity or something. In those cases, the community may exact from you, usually it's property, but it can be other things, in order to help meet those requirements, and or they may require you to pay what are called impact fees to help fund. So in other words, for example, you're going to use a certain amount of water. The city has to have a storage tank and the lines in order to deliver that amount of water to your development, and that needs to be paid for. So the city may very well be able to charge you, the developer, as a fee to say this is your share for the amount of water you're going to use and how we have to get it to you to pay for that. The big issue in exactions and impact fees is you can only charge what their impact really is. On exactions, a real common thing, I used to see this all the time early in my career, you have a subdivision that's going in, and of course they build the streets within their subdivision, but they may be up adjacent to a public street, and that public street needs to be widened because there's going to be more traffic. In many of those instances, the developer of that property was required to give up the extra right-of-way width. Bingo, just part of the process. You got to give up the right-of-way width. Well, the value of that property may be a lot more than what just the impact from his development is going to be. And therefore, it's an inappropriate exaction. There's a pretty landmark court case in Magna where that very thing was happening along 3500 South in Magna. And the developer was arguing and saying, look, I mean, I'll give property to widen the street, but I shouldn't be made to give all of that property at no cost because I'm not going to produce that much traffic that would justify that much cost. What the county had to have, because that was in the unincorporated county, what the county had to have is they had to have a pretty good transportation plan that showed what the anticipated traffic on streets was going to be in the future, what the cost of doing the improvements to meet that demand would be, and how much of that cost could be attributable to that particular subdivision. And then that's how much they could charge. If they needed more property than that, they would have to buy it from the developer. And so it's something to be aware of. And the same thing applies to impact fees. You have to have a study. You have to have the study that shows what the costs are and what that will be.
So the exaction is like a gift and the impact fee is actual fees.
Yeah. Yeah, an exaction would be like, give us 5 feet of your property. You know, in order or another common one is, you have water rights. Give us your water rights. Okay, but do you need that much water rights that the property owner may have to serve the development that they're intending? Maybe only part of that. And if you want all of the rest of it, you need to pay them for it. So it's something like that.
Sometimes like green space or.
Yes, it can be. Yep, absolutely. Development agreements is another common thing, and I'll tell you what, since I've done this presentation, they have become way more common than anything that I saw early in my career. It's, it's really gotten to the point where, yeah, politics. It's really gotten to the point where early in my career, if somebody wanted to do a development and they needed to rezone property, and the city had certain zones, and the developer says, okay, well, my project could fit into, say, this commercial zone. Well, what he wanted to do was a permitted use in that commercial zone, but so were a lot of other things, right? But okay, so the city would consider it and they would say, all right, well, okay, we'll agree to rezone the property. And the developer was usually like, great, now I can do my project. Sometimes that developer didn't do the project. Now the property was zoned that way, and anything that was listed in that zone could now be developed on that property. Oftentimes that was not a problem, you know, because you're like, okay, it's a commercial area, you can get all of these kinds of things. But sometimes the city and the people around it were like, well, look, we really approved this thinking we were just going to get this, but we didn't think we were going to get that. We don't want that. Well, the zone allows for it, but that's the way zoning worked. And that's what I was used to early in my career. It's gotten to the point now where in most communities, rezones will not be done without a development agreement. And what the development agreement does is it usually says, you get to do this specific thing and that's it. And they sign it and the city signs it, and that's it. And if the developer decides not to do that, nobody can do anything else. They're bound by that development agreement to do only that, which may make it harder for that developer to sell that property to somebody else. It can always be renegotiated. You know, they could come back to the city and say, hey, look, this isn't going to work out. I've got somebody who's interested in doing this. Can we change the development? So the city can go through that process and change it. But it's kind of a whole new ball game. For me, it's a whole new ball game. It's getting to be more and more common. But that whole issue of development agreements and the specifics of the development. You know, you're all aware of that. You've seen it in some of the stuff that we have. I mean, it's very specific about what can be done and how it can be done on that property, and it's all embodied in the development agreement. And the state Supreme Court has ruled on that and pretty much held it to that. And they have said that you can even allow for things to happen on that property that is not part of your land use code, not part of the zoning, as long as it goes through the process of the legislative process. If it goes through the legislative process, it's considered to be like going through a rezoning or a change of code and ordinance, and it can be allowed. But it goes through that process and has to have a public hearing, has to have a recommendation from the Planning Commission, and then has to be approved by the council. So, interesting stuff.
So functionally, that development agreement becomes the zoning code.
It really does.
For that property.
It really does.
We've had I had another inquiry this week, but some of you have been around long enough that you may recall that small mixed-use project we approved and entitled on 200 North and 200 West, right next to Mr. Car Wash. So it was office building up fronting 200 North, and then 3 townhomes in the back with detached garages and studio apartments. So 6 units and then some office space. In the last year, I have had several brokers reach out to me. That property has been listed for sale. And the listing brokerage has not bothered to put on the listing that there's a development agreement recorded against the property. So every time someone has come and asked me, this is what I want to do, and again, this was an email I sent yesterday. Well, you can't, because here's the development agreement, it's recorded. You either would have to amend the development agreement or rezone the property. I want to put a Starbucks there. You can't, because office space and townhomes were approved there.
And their argument is, well, the zoning would allow a Starbucks. Yes, but the
Correct.
development agreement does not.
Correct. And so, and can you amend a development agreement? Yes, I've had development agreements that have had 9 amendments, which that's super fun to track over the years. But you can always amend a development agreement, but it does set the zoning entitlement and vesting for that particular property. Now, a downside of having all the development agreements is it's very difficult for staff to track.
Yeah. That's my objection to it,
And
being an old-time planner.
yes, Wilf and I are kind of more purists in this of like, if you have a zone and these are the things that are allowed and these are the regulations, the setbacks and the heights, and you don't like that, fix your code, right? Instead of doing a development agreement, that's kind of the purist is like your zoning code, it either should be appropriate for that location or it's not. But then you bring in these other things that, now developers do tend to like development agreements, sometimes, a lot of times, because they know that's the only path towards approval. The community likes it because they know what they're going to get, and the council likes it, right? Because they're going to get that guarantee and protect the residents from those other uses that could come in without those types of protections. And, so I think it's been a mix of like, oh, well, the property sold and the original developer that said he was going to do this isn't around anymore, and now we got this, and as a community, we're very unhappy with that result. So these development agreements really have become kind of not even the trend, but the standard in many communities for getting those approved. Now, I came from Murray City 4 years ago. Murray would not do development agreements. They just flat out were like, this is what the zone says. We don't do development agreements. So, each community to their own, but
And we won't rezone here without a development agreement.
well, sometimes we will. The council has, but I'll tell you for townhomes, I don't see that ever happening without a development agreement. The mixed use zone actually requires a development agreement and a fully, not a fully, enough of a project with the with the renderings and projects so that we know exactly what we're getting, a site plan, all of those things. But you don't have to have one, except for with the mixed use zone. But I think the preference is, for the council to have those protections.
Yeah.
So how, in the process of either rezoning or redoing the development agreement, is there extra cost? Is that extra time? Do you have to do both? Or if you rezone, then the development agreement goes away? Or if it has an agreement, you have to do that first?
Yeah.
The development agreement is like a contract. It doesn't go away unless both parties agree that it's going to go away.
So the people that are selling it have to redo the, and not for one.
I mean, right, Katie? I mean, both parties would have to agree to change it. I mean,
People selling it probably don't want to go through that effort if they're wanting.
well, it depends.
If they want to sell it, they might have to.
Yeah. Yeah.
Yeah, in
Yeah.
fact, this gentleman that was, emailing about the property over there was like, well, would you guys consider a Starbucks instead of the office? Well, I'll float that around and see kind of what, but, I don't know. I mean, first of all, it's not my decision. I don't know. But that would require a development agreement amendment. And no, when you do the amendment, you don't have to go back through a public hearing process.
I think you do.
Do
I
you?
think you have to follow the legislative process.
To amend it?
If it was approved that way, it needs to follow the process
Okay.
again. Yeah.
Okay.
So, and as Melinda said, my objection to it, such as it is that keeping track of all of these development agreements, you know, especially for a big community that's growing a lot, you can have a lot of development agreements. And is everybody going to remember what there is and where they are? And, you know, just keeping track can really be a big chore. And so I think they can sometimes get overlooked or forgotten or lost even, you know, and so it really makes it tough. There is a community that was doing something similar to this long ago, but the way they did it was interesting. They would have developments proposed on property that was very specific, and they would create a zone specific to that project. And then they would rezone the property to that. And so you look at their zoning map, and the city is Orem City. If you ever want to go take a look at Orem City's zoning map, there's all these little zones all over the place, and each one's different. Each one has different stuff. Now, the benefit of that is, just looking at a map, you can see. You can say, oh, okay, there's something that applies there, and then you can go to the code book and find it and see what it is. But you want to know what Orem City's code book looks like? So, it's, you know, there's pros and cons, but that's kind of the world we live in these days.
It shouldn't be bigger than something that has to.
Yeah, so.
It's that big, you can't fit it. If it's bigger than that, it's just too big.
The last thing I want to talk about is something that you don't generally get involved with as a planning commission, but is part of the process for a developer. So let's say, as a developer, he makes the application, he gets approved, let's say for a subdivision to start to build houses. He's recorded the plat, so the properties all exist now, and he's got to build a street for the subdivision to put in the sewer and the water lines and everything else that go with it. Well, you know, from a financial standpoint and just from the standpoint of how things move in our world these days, they want to start selling lots and building houses. But it may be December or January and they can't build the street just yet. Or it's going to take them a while to build that street and put in all those lines. Well, isn't there a way that they can sell those lots and get the money? And there is. And that's basically to guarantee that those improvements are going to get built. And that's called bonding. They can bond, in other words, guarantee the money in order to put those improvements in. And they put up a bond. Everybody hates bonds. I'll tell you that, because if you've ever tried to reclaim a bond, oh my gosh, the bonding companies make it almost impossible. So most cities don't even like bonds anymore. What they basically say is you got to put up a cash deposit. Developers don't like that because it ties up their money, which is totally understandable. But by the flip side, it may be the only way to guarantee that you're going to get those improvements. So they have to put a bond in place. They can start selling their lots. They can start building houses. They can start doing whatever to get the cash flow moving there. And then when they're able to, or as time goes along, they get those improvements built and put in. Generally what happens though, when they finish those improvements, then for a period of time, the city requires that there is a guarantee period, a warranty period, that they have to show, it has to be shown that they built it to standard and it's going to last. So they usually say a year or two, and we're going to keep 10% of your bond in order to guarantee that if there are any repairs that have to be made to that, we've got the money to do it.
Would that be like that overpass?
Is it like what?
Would that be like the Kaysville overpass that started to like?
Yeah, but in that case, I think that was built by the state.
No, it would be like you could have your road settle, or
Yeah.
I've had experiences where the flat work, like the sidewalk, the concrete starts spalling. because it wasn't the
Weather wasn't right, or the mix wasn't right.
correct,
or
yeah. Weather could be too cold. You have to put blankets on in the colder temperatures so that it can cure correctly. You could have infrastructure pipes that fail, right? Like, so it is important to have that warranty period.
Yep. So that's just something the developer needs to be aware of, that for a period of time, something like up to 10% of their money for those improvements is going to get held to guarantee or warranty that those improvements are going to.
And that protects our taxpayers, because at the end of that warranty, if it's going to be public infrastructure, right, not for private roads, but when that's going to become public infrastructure, we want to make sure that the work quality, and we do inspect throughout the process too, that it was done correctly, that it was, installed correctly, and you pass that warranty period, because otherwise, that road fails, that's on the taxpayers. So we're pretty careful about that.
So without bonding, you have to put in the street sidewalks and all that before.
Right.
And so is that why, 'cause I noticed that you always have sidewalks come in, and then the trucks break them.
Right.
As they're doing construction.
Yep.
So they do it twice.
Yep.
Sometimes.
Yep. That happens a lot. And the cities usually require that. They say, before they'll pass off and say, we'll accept this improvement, they'll go out and inspect it. And they'll say, broken sidewalk, broken curb, broken approach, you got to fix all that before the city will release the bond and accept your improvements. That gets sometimes contentious between the developer and the city, because sometimes the developer says, I didn't do that, that wasn't my fault. And it's outside the warranty period, and it can get interesting, what happens. But it's part of the process. It's part of what happens, and so that's something that someone who's attempting to develop has to be aware of. Not something you all usually get involved with, but just part of that whole development process. So that's pretty much it. You go through all of that, and now the applicant can build. They can go forth and provide. So with that, questions, comments, anything? I'm done.
Chair, I was wondering if I could have a do-over on the ex parte question. I was reading more about it. You should be the least concerned if it's legislative, the most concerned if it's quasi-judicial, but best practice is to not have ex parte communications on administrative, but if you do, to disclose them so that the applicant has a chance to respond. I think that's a better answer.
Explain ex parte.
Which means like talking with somebody about it outside of the meeting.
It's like you're at the grocery store, or somebody calls you up and they say, hey, look, I know you're going to be considering this. Here's why I don't like it. Here's what I think is the problem with it. And
Like your neighbor
So
calls
you
you.
think you should disclose, now what if you feel like it's irrelevant?
that's fine, but I've always told my planning commissioners, I've said, you get any communication, contact about the project from anybody, when you're at the meeting, just say, I got a call, and this is what we talked about. And just explain what happened. Or I ran into such and such at the grocery store, and this is what we talked about. And once it's all out on the table, everybody knows about it, great. And you move forward.
Which is probably really difficult when you live in the community where you're serving. I know, at least for me, sometimes when I live where I work, I'm going to get lots of phone calls and run into people at school things or at the grocery store, and there's lots of questions, and it's hard to, you just kind of just smile and, you can't say too much. Unless it's the right topic, and then I'll tell you anything you want to know. I'm just kidding.
And you see all kinds of reactions. There are some people that will say, they get somebody that comes up to them and says, hey, I want to talk to you about this, and they'll say, no, I cannot talk about this. Leave me alone. Get away from me.
Ethics.
And others that just kind of will listen, and they'll nod and they'll smile, but they won't, tip their hand about what they think about what that person's saying. But that way, you kind of let the person go off. And then when you get to the meeting, you can just say, yeah, somebody talked to me about this. And this is what they said. And that's it.
matters? Do we have other matters to discuss?
Well, we do have minutes to consider.
Whole 24 pages of them.
I know. Or was it 28?
That fit on the back of it?
No.
I had to put it on the public meeting, or when you put on the state's website, you have to put all the minutes on it, and I had to put it in 2 sections.
Wow.
So,
Okay, any concerns for the minutes?
Motion to approve the minutes, January 8th, 2026.
Discussion? All in favor?
Aye.
Okay, passes.
Okay, other matters. Well, first of all, January is a glorious month because there's a fifth Thursday, which means as staff, we get a bit of a break from our continuous deadlines of public hearing notices, staff reports for council, or a planning commission packet. So maybe not tomorrow, but next week we'll be mailing out public hearing notices for 3 rezones. 2 will be for parks that the city owns, one for Pioneer Park, and then, do they call it Choppers Field? Or so the Choppers Park up on 200 North by Bonneville Lane. Yeah, Schick. It was part of the Schick Farms subdivision. It actually was HOA space that they came to the city several years ago and said, we can't afford to maintain this. We took over the property as a public park. But those properties are not zoned public use. Like Pioneer Park is zoned residential agricultural, I think.
Yeah, and then one of the Choppers Field parcels is zoned, I think, RA, and the other one is zoned R1LD.
Yeah, so we're when we have meeting dates that don't have applications or lighter meeting dates, we're going to bring, there's multiple properties in the city that we want to do this with. So we'll have those 2, and then we had another rezone application for a property just down here, the state, no, it's not. America Family Insurance, just right over here on 100 West. They called Ann the other day, wanted to put in a particular type of sign that's not allowed in the professional business zone. So they want to rezone to central commercial so they could put the type of sign in that they would want, which would be a pole sign. So we're going to, we'll have that on February 12th, as well as the 2 parks to be rezoned. And then at this moment, the plan is to probably have the Symphony rezone back on the agenda for February 26th. So I think that really is about it. And then we'll also be bringing, maybe we could get the bylaws done on the 12th as well. At least start a discussion with that. So we'll make some amendments to the bylaws. I think there seemed to be some consensus about, the council doesn't allow to yield time to other, from one speaker to another. I have concerns about, creating disequity when we do those types of things. Obviously, that would be up to the, preference of the Planning Commission. And again, we can always suspend those rules if we want. Like sometimes we have rezones and you only have 2 people commenting. And so if you go more than 3 minutes, that may be okay in that setting. But when we do have those large meetings with lots of people that want to come and speak, it just creates, I think, kind of issues of concern and just not having fairness and equity with each person having the same amount of time. So there's a few other things that we've looked at that we probably want to amend. We last amended those, I think it's been about 2 years. So it's good to keep those current as well. Anything else? Okay. Anne? Katie? Anyone else? Okay. Well, thank you for being here. State law does require that planning commissioners have at least 4 hours of training per year.
When's that year start? Is that a July? It's calendar.
Yeah.
Okay. So we'll start-
It probably doesn't. But, and then you're actually supposed to, and then the annual public OPMA meeting that Katie did, that's supposed to be done annually. So we've checked some boxes tonight. So thanks for being here. And I understand that some of you were at the first night of Kaysville University last night. So thanks to those who were able to attend. Next week it will be me and Marin, our finance director. So we won't do a repeat of this training next week for those of you that'll be there, but I'll talk about other areas of our community development department that we just don't really get into here. So I can go over a little bit more of our building permit process and business licensing, which is actually Mindy's primary role. So we'll get into some fun details about that, and we'll just stay tuned.
Say that with a little more enthusiasm.
I know, it was great. Good.
It was, yeah.
And they kind of made the comment, you made it through legal and IT, so it's up from here. But even still, I was like, gosh, it just blows my mind at how much I don't realize goes on. You know, it's crazy.
Yeah, like one of the things that, I don't know if Ryan, our IT director, talked about this at all last night, but okay, a lot of what we do here is state mandated. And the state has come out with basically privacy protections that we have to include in. And so, like, we have gone through the process of identifying what information we take in from the public. And if there's anything that identifies you as an individual, like when you applied for your planning commission application, we keep those applications. We have to define what we keep, where it's stored, and then we have to have a privacy disclosure. Like, there's a lot that we do that, we have to, things that we do that are, not because we have to, but there's a lot that goes on. Yeah. When I was working for the city of Chandler in Arizona, this was right after my graduated with my MPA, and but they had I don't know what they called it, but Chandler did one as well, and it was like a 12-week program. The stuff with fire and police definitely was the most exciting, and but the value that I learned, especially as like an intern or being in my first couple years of my career, was just really invaluable to keep that in mind going forward with. There's just things that you would never know that we do.
When I first started at the Park and Rec department, our director took me for a 3-hour tour, literally like a 3-hour tour. You guys remember where that's coming? Yes. So it should have been like a 30-minute tour, but after he took me around, you catch it now. It was much longer. Vance was getting ready to retire, and so I think he was kind of having a swan song, and he was showing me all the trees that he loved and all of these things. But it was so great because I took total ownership of the city, because then once I drove over the bridge, I'm like, telling my husband, like, they used to like Easter eggs, and now we have to color them, so they've been, like, there's little things that once you start learning about the city, it personalizes it, and it just makes you, it just endears me a lot more to my city, because I know how the parks work now, and so you guys are privy to that information. That will be super great at dinner parties. So I get invited to lunch because my friends all want to know which businesses are coming in or like what's going on. So
I don't get invited to lunch because
you know too much.
that's true. No, because people don't like the recommendations that come out of my staff reports, but that's another story. So, okay. Well, thank you again for being here, and
Adjourn the meeting.
yeah.
bet, thank you.
Good job. Appreciate it.
Thanks.